Good afternoon, ladies and gentlemen, and welcome to this first webinar of the year organized by the East Africa Law Society Institute. Our training today will look at how to extract electronic evidence and how to extract that evidence in a way that is admissible in a court of law. I know most of us have at some point in our legal practice careers encountered cases that involves the presentation of electronic evidence in courts, and we have faced challenges here and there on how you can either acquire that evidence or present it in court. And that's the reason why we are undertaking this capacity building for members to be able to understand how they can secure electronic evidence, present it in court, and effectively represent their clients in matters that involve cybercrime, and especially given that most of these matters have a transnational element to them. So to facilitate this session, we have a really experienced cyber forensics expert, Mr. Lawrence Dinga. And to moderate for us the session, we have Ms. Gigi Maja, who is a senior associate at Tanzania's leading law firm, Rex Attorneys, and with lots of legal experience, some of it in this particular area. So I'm going to welcome Ms. Maja to kick us off and welcome the presenter for today. Thank you.
Thank you, David. Happy New Year again. As David said, my name is Gigi Maja. I'm from Rex Advocates or Rex Attorneys in Tanzania. I'll be your moderator for this session. Before we get started off, I'll just like to lay some ground rules for the sessions, please. If we could all be cordial enough to let the presenter present his slides without interruptions. And then should anyone have any questions, any queries, any comments, that we hold them off until the end. Or during the session, you can type your questions and comments or queries in the Q&A, or you could raise your hand at the end and then we'll take it up from there. Now, if you will allow me, I would love to take this honor to introduce today's presenter. His name is Mr. Lawrence Dinga, and he is a seasoned consultant with a wealth of experience in cybersecurity, in digital forensics, in cybercrime investigations, and in cyber capacity building. Mr. Dinga holds a master's degree in forensics computing and security. This is from the University of Derby in England. He also has an LLM in ICT, which is from the Open University of Tanzania. He also has a diploma in law from the Kenya Law School, and he's also what they call a CISSP, which is a certified information system security professional. Now, Mr. Lawrence has, at the moment, he acts as a digital forensics expert for expert witnesses, and he does this in an international arena. He has been involved in different organizations, starting from the Cybercrime Program Office for the Council of Europe, to the European Union Agency for Law Enforcement and Training, to the Council for Europe with regards to capacity building for legal professionals, for conducting research, etc. He also acts as a trainer on cybersecurity and law at the Kenya School of Law, as well as the United Nations Office on Issues of Drug and Crime, which is the UNODC. So in short, Mr. Dinga is a great expert in his field, and he's literally worked within the sub-Saharan region with regards to with cybersecurity and electronic evidence. Now, for today's session, what our wonderful presenter is going to be doing is going to be introducing us to electronic evidence and into what the characteristics and sources for electronic evidence is, as well as give us the principles of the best practices for handling such evidence. Lawrence, if you'd like to take it away, please.
Thank you, Gigi, for that introduction. Good afternoon, ladies and gentlemen, and I would like to take this opportunity to welcome you to this first session of extracting legally admissible evidence.
Sorry, Lawrence. Can you maybe increase your volume a little bit? I'm not sure if it's perfect. Thank you.
Can you hear me now?
Yes, much better. Thank you.
All right. Yeah, I was just saying that I would like to welcome everybody today in this webinar on series of webinar on digital evidence. And today we are going to look at admissibility of electronic evidence. When I say sometimes I use digital evidence or I use electronic evidence, there's no difference. It depends on which jurisdiction you are. You find that some jurisdiction will always use digital evidence and jurisdiction will use electronic evidence. So if you can allow me to share my screen, Iggy. Can you be able to see my screen fully? Can you be able to see my screen?
Yes, we can see it. Thank you.
Now, this first session, we are going to look at the admissibility of electronic evidence. What I would like to say before we start with that, electronic evidence is something that is fragile, and how you treat it depends on the result that you are going to get when you go to court. So the admissibility of electronic evidence is actually affected by so many things. From the time you collect that evidence, how you collected that evidence, how you preserve that evidence, how that evidence was analyzed, and how you present that evidence in the court of law. Not forgetting what we call the chain of custody, because if the court can know that the chain of custody has been broken, then that evidence comes down. So in this session, this first session, we are just going to look at the following learning objectives. So by the end of this session, you will be able to learn the following. You will be able to explain the role of electronic evidence. Then you will be able to describe the characteristics of electronic evidence, and then discuss some principles in handling electronic evidence. There are certain principles that you need to follow for that evidence to be admissible in the court of law. And then there will also describe the life cycle of electronic evidence. So just straight away, before we actually look at that admissibility, it's important that we understand what we mean by electronic evidence. For our next slide. Now, when we talk about electronic evidence, we know that compared to any other evidence, physical evidence, electronic evidence has some challenges to the first responder. What do I mean by first responder? First responder is that person who arrives at the scene of crime to actually collect that evidence. Now, you find that not the way you collect physical evidence is not actually the way you be able to collect electronic evidence. So what is electronic evidence by definition? I take this definition from Casey 2011, and the electronic evidence can be defined as information stored or transmitted in electronic format that is used in legal proceedings by a party. Now, if we talk about electronic information stored in and transmitted in electronic format, now where do you find this? You'll find that electronic format, information can be found in things like laptop, mobile devices, on all those electronic gadgets. But now, we need to also differentiate between this digital or electronic evidence. Now, if you go to a place and
Lawrence?
yes.
My apologies to interrupt you. I am seeing some comments that
Yes.
your audio has an echo. My apologies for interrupting you.
It's an,
There are some comments on the webinar chat that the sounding is a bit problematic, that it has a bit of an echo.
Can you hear me now? Is it still echoing?
This sounds much better than with the earpiece.
Okay, so I've removed the earpiece. I think I can hear you very well.
Yes, thank you. Apologies for the interruption.
It's okay. So there's no echo now? Can everybody hear well?
Yes, they're saying it's better now.
All right, all right. Thank you very much. Now, I was saying that when we are talking about electronic evidence or information which is stored in and transmitted in electronic format and used in legal proceeding as the definition of the electronic evidence, we find that you can find this, you can differentiate between this evidence in that when I come to collect evidence and I find that this evidence is actually found on a desktop or a laptop, which is actually sitting somewhere, and I need to collect this evidence. This evidence is actually persistent, which means that the evidence is actually in that particular device. So what I do is I employ some means to collect that evidence, and this evidence is actually static in nature, what we call dead box when we are doing forensics, which means that you are collecting evidence from a device that is either shut down or is inactive. So there's a way you will be able to collect that evidence. That is static evidence, collecting evidence from a device that is that is off. Now, sometimes as an investigator, you might go to a place, let's say it is a company, and you are told that, yeah, this is the device that has got data. You go to a place and they say that the data that you are looking for is actually found in our corporate server. In that case, it is not possible for you to go to and take that server and take it to the laboratory or shut it down so that you can collect that evidence. It will not be possible because at that moment, people are using that particular computer or that particular server. So in that case, if that is the culprit device where you need to collect the evidence, then you need to collect the evidence while that particular device is on, which means that you are collecting evidence from memory of a server, or sometimes even if it is a server, it's not a server, but it is, let's say, a desktop, and you find it is on. When a computer is on, there's a lot of information that is found in the memory. That is what we call a random access memory. This is a memory that when the computer is off, then that memory, the content of that memory disappears. So if you as an investigator, you suspect that this is the computer that has got information, then it will force you, before you shut down that computer and take it to the laboratory for dead box forensics, what you do, you'll pick the content in the memory. Why is this important? This is important, especially when you are doing investigation, and these cyber criminals are always very, very smart. They know that they encrypt their hard disk, they encrypt their computer, so that when that computer is off, then for you to bring it on, then you'll need to have the encryption key. You have to input the encryption key for that computer to come on. So if you go to a place and you find that the computer is on, one of the reasons why you should not put it off and collect information from the memory is that the encryption key may be found in the memory, so that once you collect the content of the memory, you can later on do forensics, memory forensics, and find the encryption key. So that is the second way, or the second type of electronic information. The other one is internet data. Nowadays, a lot of things happen in the internet, And for you to start even investigation, the first thing that you'll do is you'll do reconnaissance on the internet. If I'm trying to investigate somebody, the best place that I can get proper information is actually on the internet. So you can start investigation from the internet, collecting what we call data from the internet data. This is what we normally call intelligence, open source intelligence. So you taking data, you are collecting data from open source intelligence and converting this data into evidence that can be presented in the court of law. So that is actually the definition of electronic evidence. As I said, I might use the term electronic evidence, or I might use the term digital evidence. It depends on which jurisdiction you are talking about, but it's all mean the same thing. Now, what is the difference between electronic and traditional evidence? Now, electronic evidence is no different from traditional evidence. Now, the most important thing is that the party that is introducing electronic evidence in a legal proceeding must be able to demonstrate that it is no more or less than it was when it came into their position. What do I mean? This evidence, when it was collected from the scene of crime, and it was preserved, and it was analyzed, and then it was brought to court, the court must be convinced that there's nothing which has been done on this evidence. There's nothing which has interfered with this evidence. There's no changes, there are no deletions, there are no additions, there's no any alteration that's had taken place since this evidence was collected. So that is very important, because if the court can establish that there are some changes that have taken place since this evidence was collected, then it will not meet the legal threshold for it to be admitted as electronic evidence. Now, this is because electronic evidence is easier to manipulate than traditional evidence. Electronic evidence should be handled in a manner that ensures its integrity is maintained and can be proved in court. Now, throughout this session, you'll hear me talking about integrity. Integrity is very, very important in electronic evidence, because integrity will prove to the court that this evidence has not been interfered with, this evidence is original, and this evidence can be admitted, legally admitted in the court of law, because it meets the legal threshold. So as as I said, electronic evidence and traditional evidence is the same, except those characteristics of digital evidence or electronic evidence that need to be met. Now, what is the role of electronic evidence in a case? Now, the role of electronic evidence is actually to establish a credible link between the attacker, the victim, and the crime scene. Now, this can be illustrated in a physical environment, what we call Locard's exchange principle. Now, Locard exchange principle states that anyone or anything entering a crime scene takes something of a crime scene with them and leaves something of themselves behind when they leave the crime scene. Now, what does this mean? If you are the criminal and you go to a place, let's say somebody's house, and you killed this person. Now, as you are entering that crime scene, maybe you did not have gloves and you touch the lock. Now, by touching the lock, you've actually left your DNA or fingerprint on the lock. So you can see that you are entering a crime scene and you have left something. And let's say you are killing this person and the blood splits from him into your, maybe onto your clothes. Then you can, as you are leaving, even the hair, as you are leaving, you see that you have picked something from the crime scene. So that is what the Locard exchange principle. And this Locard exchange principle actually applies into the digital environment. And that is why this saying that whatever happens in Vegas remains in Vegas. Whatever happens in the internet remains in the internet. So everything that you do on a computer or a network will leave a trace. This implies from deleted files and registry entries to internet history. And that is why sometimes when you go to your browser and you had gone to a site the previous day, when you start typing, then you've seen that whatever you had typed the previous day will automatically pop up, because that is actually stored on the browser. So sorry. So something like email. When you send an email has got what we call email header. Instant messages have got something called logs. So all these things, when you use an email, it will actually carry all the clues as to where this email was sent from, where this email, how this email transfers through the internet until it reached the destination. If you also logging onto the server will have all the logs that about how you, whatever you accessed in that system or whatever you access from that website. So this is actually what the role the electronic evidence will play. It will you'll actually leave traces that can be used as evidence when presented in the court. Now, what are some of the characteristics of electronic evidence? Electronic evidence, as we said, has some unique characteristics which are different from physical evidence. Now, electronic evidence, as we can say, it is invisible to untrained eyes. Why do I say so? If you are not trained how to identify electronic evidence, it will be very difficult for you to collect that evidence in a manner that it will be admissible in the court of law, because it is found in places where only specialists would search or in location only reachable or by special tools. So which means that you need some special tool, you need some special skills to be able to collect this evidence and analyze this evidence. So electronic evidence is actually invisible to untrained eyes. You need some training for you to collect this evidence. Electronic evidence is also highly volatile. So data can easily be overwritten by a normal computer procedure. Like when new data is written on top of all the data because of lack of memory. For example, your computer is full, your hard disk is full, so it forces it to delete some files when you are saving some files. So which means that whatever is deleted, it is not easy to recover. But it can recover, but it's not, you need to follow some steps. So it can, this makes it highly volatile, which means that it can be overwritten just by a normal computer procedure. It can also be corrupted due to an environment, like if it is subjected to heat, if it's subjected to humidity, if due to electromagnetic fields, this evidence can actually be corrupted. So electronic evidence is highly volatile. So the first one, it is invisible to untrained eyes. You need special trainings and special tools to access this evidence and collect it in a legally admissible way. And then the second thing is that it is highly volatile. The other characteristic is that electronic evidence may get deleted or destroyed through normal computer use. For example, if you are saving a file, if you save a file on top of another file, then automatically the content of the previous files is actually deleted. It's automatically deleted by replaced by the new files. So in a normal computer operation, electronic evidence can get deleted or destroyed. Now, electronic evidence is also can be copied without degradation. Electronic evidence information can be copied indefinitely with each copy exactly the same as the original. multiple copies of the evidence can be examined independently and without affecting the original. Now, I want to give a caution here. When we talk about copying without degradation, it is not necessarily that when you need to collect evidence from your laptop, then you just go and hook a USB, and then you copy the files and paste it somewhere, and then you take it to court for as evidence. It will not actually be admitted because it is not same as the original. Now, and also sometimes you find that when you go and collect evidence from, let's say, a computer, and you take it to court, you are not supposed to analyze the original evidence, because you may interfere with its integrity, and maybe if that case is not over, then the opposing party may decide that, okay, we also need to do our own investigation. So it will be very difficult. What copying here means is that when I want to collect the evidence from let's say a laptop or a desktop, then what I do is I do what we call bit by bit copy of that original evidence, or what we call clone, so that I have an image of that evidence and as a file and copy somewhere. Once I do that image creates what we call hash value. And hash value is just a mathematical function that is performed when you are collecting that evidence to show that the original evidence is actually the same as image evidence, so that you know that when you do analysis on the image, then actually you have you've done the analysis on the original evidence. So when you go to court, you'll have the original evidence that was collected, but when the analysis, what you presented in court was actually analyzed on image of that original evidence. So image is a bit by bit copy, picking everything from that particular hard disk the device, and ensuring that after copying, it actually calculate that hash value to ensure that the original and the image is the same. So that is what we mean by electronic evidence can be copied without gradations. So you can make many of the images and do analysis without actually interfering with the original evidence. Now, there are certain principles that you need to observe when you are actually collecting evidence. Now, one of the principles is data integrity. Now, electronic evidence and data must not be changed either in relation to hardware or software. The integrity of evidence and the chain of custody must be maintained at all times. Choose an action that causes least alteration to data when accessing a running device. This must be done by a qualified officer. Now, what does it mean? As I said, integrity is something that I'll talk on throughout this session, because that integrity is actually what makes that evidence be admissible in court. So anything that you are doing on that evidence, when you are doing the collection, when you are doing preservation, when you are doing the analysis, that electronic device or that evidence that you are working on should not be changed in any way, either in relation to the hardware itself or software itself, because integrity is very important. Another aspect which we are going to see later is what we call the chain of custody. Now, the chain of custody means that by the time there is a chronological documentation of everything that has been done, has happened to that evidence from the time it is collected to the time that evidence is presented in the court of law. That chain of custody is a proof that actually this evidence has not changed, and you can prove that in the court of law, so that the evidence can be admissible. Now, I was an expert witness in a case sometimes back, and what happened is that the investigators did the investigation, and then they actually took the device they used to collect the evidence and transfer the content of that evidence into a CD. Then they, first of all, deposited this device in the court, but later on, they actually came and collected it, claiming that this device had got some information that they wanted to use. Now, at that point, before this case ends, the chain of custody has been broken. And if somebody brings an issue of the integrity, they can actually do what? They can actually win, because the chain of custody has been broken. So that chain of custody needs to be maintained from the time the evidence is collected to the time that the evidence is presented in the court of law. Integrity is very, very important as a principle in handling electronic evidence. The other thing is what we call audit trail. And this audit trail actually is something that is actually needed, is important in the handling of electronic evidence. It means that you document all action accurately to enable third party to assess the officer's action. Now, the document must be kept and available for review. Now, why is audit trail very important? Audit trail is very important because whatever you are doing, we didn't know what you're doing, but if you are doing things in the correct way, then when it is documented, I can actually follow exactly what you are doing. And if the third party says that we are not satisfied by what we've seen or how the investigation has been done, then they can take the same evidence, they can follow the same procedure, and they are supposed to arrive at the same result. So documenting each and everything that you are doing will enable that party to assess your action. And this will be able to convince the court that actually this evidence has maintained its integrity. Now, the other principle is specialist support. Now, specialist support either within the agency or external party, they're assuming that this is at the time of investigation. It can assist the first responder in performing tasks, especially where case involve high-tech crime. Now, why I say that one of the characteristics was that digital evidence or electronic evidence is invisible to untrained eyes, which means that if you are a first responder, and I say first responder is that person who responds to the first in the scene of crime. Now, if you are the first responder and you have no knowledge, you do not have that trained eye to actually collect that evidence, then it is important that you don't interfere with that evidence and wait and call the person who is experienced in doing that. The person you are calling must have the expertise and experience in the field of forensics. That person must also have the knowledge and skills in conducting investigation. That person must have some legal knowledge, and he must be a good communicator, both orally and in written form. And what is more important is that the person must have authority or legal justification for his or her involvement in that particular case. So specialist support is important as a principle in handling digital evidence, because if you handle it in a way that is not correct, then that evidence is actually not going to be admissible in the court of law. Now, then the fourth principle is what we call the appropriate training. Appropriate training here means that the first responder must be trained in both technical and legal aspects. If possible, the knowledge and skill must be tested to ensure that the competency of the first responder. Now, continuous training is important and is always conducted to ensure that the first responder is kept abreast with the current technology. This means that if you are that person who collects the electronic evidence, so that person who goes to the field to collect evidence, then it's a must that you must have both the technical and legal training. You must be trained in these areas to help you collect this evidence sufficiently in a way that meets the legal threshold. Because what the problem that I've always experienced is that most of the investigators, almost the people of the first responders, are never trained to collect this evidence, and that's why you find that by the time they collect that evidence, they've already interfered with it, and when it goes to court, then that evidence will not be admitted as in the court of law. The other thing is legality, is as a principle of handling electronic evidence. Now, the officer or the agency in charge of the case are responsible for ensuring that the authority, evidential safeguards, general forensic and procedural principles are followed accordingly, which means that collecting evidence, this evidence, electronic evidence, is one way. Part of it is science, part of it is illegal. So which means that if you are collecting this evidence that is going to go to the court of law, then you must have the legal authority to collect that evidence. Now, you have to, once you have that legal authority, you have to make sure that everything that is in your capacity to safeguard this evidence is you actually undertake that. You must make sure that all the procedures, all the principles are followed accordingly, because you are the person who is in charge of collecting that evidence. And you must make sure that that evidence is collected in a way that will satisfy the threshold of the court, legally admissible. Now, let's look at the admissibility of of electronic evidence. Now, electronic evidence, first of all, electronic evidence must be collected in compliance with the existing national legislation and best practice to ensure the admissibility at trial. Now, each and every jurisdiction will have some sort of a national legislation to be followed when you are collecting evidence. And now this also includes the electronic evidence. First of all, the person collecting, the investigator who goes to collect that evidence, must ensure that they have the legal authority to acquire and collect electronic evidence. This is because when you collect an evidence without legal authority, that evidence is not going to be admissible in the court of law, even though you've done your investigation and you have proof that this is the evidence, it has not been interfered with, but lack of legal authority to collect that evidence will make it inadmissible in the court of law. And this is why sometimes when you are going to collect evidence, you need to go to get the legal authority from the court so that you can go to that place. And that legal authority, in terms of search warrant, in America they call Anton Pillar, that legal authority must specify exactly what you are going to collect from that scene of crime. If you say that you are only going to collect 2 computers, it has to be 2 computers. If you collect extra, then that extra is not going to be legally admissible because it's not in the search warrant or in an Anton Pillar. So it is important that whatever you're going to collect is actually covered in the legal authority that you are going with to collect that evidence. Now, the other admissibility aspect of evidence is what we call authenticity. Now, authenticity means that the evidence must be shown, it must be shown that the evidence is what it purports to be, which means it is authentic, which means that it is genuine and matches the claims made about it. If there can be any test which is carried out either in the court or through the defense, that this evidence can show that this evidence is not authentic, then that evidence is not going to be admissible in law. Authenticity just means that that evidence actually is genuine and that evidence matches what it claims to be. The other thing is relevance. Now, relevance is determined by what electronic evidence, or whether electronic evidence establishes a credible link between the perpetrator and the target or the crime scene. If I collect evidence today, can I be able to relate that evidence with the perpetrator or with the culprit or with the crime scene? I'll just give you an example in a case that I also I was an expert witness. And this case, I'm telling you, my client was acquitted because the prosecution had done investigation and they had written a report. And then my client just called me to look at the report and the video and the CD that was transferred to the CD. And I poke hole in a lot of things that I saw on that report. But the most important that actually nailed the case was this issue of relevance. The CD, the CD that they brought as evidence, the date when they were transferring this collecting evidence using this particular device, they failed to change the date to the current date. So the date was reading, for example, the date was reading 2014 and the case was 2018. So I noted, that is the first thing that I noted when I watched the CD, the video on the CD. And I just brought that thing in code. I told the code that, look here, there's no this evidence, this electronic evidence that has been brought here does not have any credible link between the case and the evidence itself, because the evidence, the CD is reading 2014 and the case is 2018. So relevance is very, very important when you are bringing that evidence in court, just to make sure that it establishes a credible link between the perpetrator and the target. The other thing is integrity. And as I said, we are going to talk about integrity here forever and ever, because integrity is very, very important. Integrity is something that is core when you are presenting evidence in the electronic evidence in the court of law. So there must be proof that the electronic evidence has not been either altered inadvertently or intentionally. If that can be proved, then that evidence is actually admissible. The other aspect of admissibility is what we call the reliability. There must be nothing about the way in which the evidence was collected and subsequently handled that may cast doubt on its authenticity or veracity. And then the other thing is what we call credibility. Credibility is a measure of witness, whether or not that witness is worthy of belief, and a witness might be considered credible if they have reliable information about the event. Now, I want to explain this in relation to the electronic evidence. Now, in actual, in the physical world, let's say somebody witnesses an accident, they can go and give testimony, they can go and be witness in the court of law. But in case of digital or electronic evidence, credibility of that particular witness is very important. And this credibility is taken into consideration, it takes into consideration your education in terms of how to collect electronic evidence, your experience, because when you go to court, you must be somebody who is credible in terms of collecting electronic evidence. The judge will, or the magistrate or the jury will only listen to somebody who has got the right training and education in this field. And that is why you are called an expert witness. And your testimony is very important because it's going to help the trial of fact to make a decision on certain things. So when you go to the court of law, and that is why once you do your report, always you find that you go to court and you have to carry your certificates, your certified certificate, and you need to pass them to the magistrates or to the jury to actually ascertain that you are somebody qualified to do that. So credibility is very important. So, and credibility, when you go to court, there's a way that even when you present that evidence, people will actually see that this person actually is credible. This person knows exactly what is talking about. Now, the last thing is validity. Validity is one way to demonstrate that electronic evidence is reliable is by showing that it was collected in a valid manner. The way that that evidence was collected, whether scientific principles were used to preserve, acquire, and analyze electronic evidence, and standards were met to handle and examine that electronic evidence. That is very important. Validity. When you you analyze that evidence, when you collected that evidence, were there scientific principles that were used to ensure that that evidence was collected properly, it was preserved properly, it was acquired properly, and it was analyzed properly. So validity is very important as an aspect of admissibility of evidence. So what are some of the sources of evidence? We know that we say that anything that is stored and transmitted on electronic evidence, electronic device is potential evidence or electronic evidence. So if you have any of these electronic devices, there's a lot of evidence that can be extracted from there. A picture can be extracted from a digital camera, from a video. Audio can be extracted, and you see a picture, for example, when you take a picture and that particular in that device, a location was enabled, then it will be able to show when that picture, where that picture was taken, information about when that picture was taken, and other information that can actually be presented in the court of law, provided that you extract that information in a way that is does not interfere with its integrity. Mobile phones, I think this is now the main area where a lot of cybercrime happens, and there's a lot of evidence there on mobile phones. So in the mobile phones, you can get pictures that can be presented in the court of law as evidence. You can get videos, you can get audios, you can get text messages, a lot of information that can be got from mobile phone. Location data, cell sites, you can get contacts. These are information that can be collected from evidence and compiled in a way that they are legally admissible and presentable in the court of law. Computers has got a lot of information. Computers have got the same type of evidence that can be found on laptop or desktop computer, the same type of evidence that can be found on mobile phone, because mobile phone nowadays are just like computers. I mean, you're working with a mobile, which is just where you do everything. So a lot of information can be found there. Mobile devices, things like iPad, have got a lot of information that is there that can be actually collected in a legally admissible way. And these mobile devices can be presented in a court of law as evidence. So storage devices, this one is a lot of, we nowadays have a lot of storage devices. Everything has got a store. Whatever has got storage, if it storage, that thing has got data. And that data is what we are looking for as evidence. There's a lot of things that can that fits within these storage devices, because you remember, as when you talk about analyzing that evidence using forensics is actually analyzing information that is stored on computer or any other digital device. Wearable technologies, I think this has got a lot of the evidence, because nowadays we wear these gears, we wear Googles which have got storage, we wear watches that have got storage. This has got a lot of information that can be collected. So what is important here is just to actually know how you will be able to collect this evidence from these devices. Internet of Things, this is endless possibilities. Now, Internet of Things, these are appliances that are connected to the internet. In anything that is intelligence that can be connected to the internet, that thing has got can have a lot of information, can have a lot of evidence, because with the IP or Internet Protocol version 6, it gives us a lot of space which can accommodate billions of devices that can be connected to the internet. Now, nowadays, you can see that you can have your refrigerator connected to the internet. An intelligence refrigerator which will look at the stock which it has and then make an order. We have smart homes nowadays that are connected to the internet. We have autonomous farming equipment, health monitors, we have pacemakers. We have a lot of things that are what we call the Internet of Things, the Internet of everything, that anything that has got intelligence that can be connected to the internet, that thing is a possible candidate for electronic evidence. And you can be able to pick electronic evidence and present that evidence in the court of law, provided you follow the principles of handling that evidence, you follow proper ways of collecting that evidence so that it can be admissible in the court of law. Now, let's look at the procedures and best practices of collecting evidence. Now, we talked, when I was starting this, we talked about what we call dead box. Now, first of all, before you go and collect evidence in a court of law from a crime scene, we say that you need to get the warrant or the legal authority. Now, you go there are two ways of collecting that, three ways of collecting that the evidence that I had explained. When you go and you see that this computer that you are collecting evidence from is not on, then don't even put it on. Just collect that evidence, take it to the laboratory and start the analysis. That is what we call dead box. Dead box means that you are seizing a computer or a device that is in off state. It is not on. That is dead box. And there are several scenarios here. You can confiscate electronic equipment and storage media. You just go and you say, okay, these are the devices, I collect them, I take them to the lab. But sometimes it becomes difficult that to do this. So what you do is you seize by copying the entire memory or content, or what we call imaging. You remember what I talked about? I talked about when you are copying the entire hard disk and into an image and making sure that you can hash that image for integrity purposes. This is what we call seizure by copying the entire memory. And why does it happen? You might not have a space in your laboratory to go and keep all these physical devices. So what you do is you'll have a storage. You go to a crime scene with your storage. Then what you do is that for each and every culprit device, you connect your storage and do the imaging or do the mirroring of that particular device, and then you leave that device on site. You don't take it to the laboratory. That is what we call seizure by copying the entire memory. Or sometimes you just you don't want to deal with the devices. You want just take the backup of the storage media. Then we talked about live data forensics, which means that you go there and by any means you cannot be able to pick that computer and take it to the laboratory, and that computer is on. So live forensics means that you are collecting evidence from a computer or a device that is on. So what you do is that you do what we call seizure by selecting data copying, which means that you only copy a certain partitions which you think has got data. And then we have seizure of evidence from the internet. And as I said, when you're starting to do investigation, what you do first, you can do what reconnaissance or what we call open source intelligence. And then once you got the data through your open source intelligence techniques, then you that data can become an evidence that can be used in court of law. So let's look at seizure of equipment or storage media. Now here, you can only use this method when you go to a place and you find that the either is a standalone PC or a small network. It is easier to collect this and go with them to the lab and do the analysis. Now you do this when there is no high risk or high financial or other loss that may be caused by non-operational or unavailability of this confiscated device, which means that I go there and I find it is one computer or two computers. And when I collect it and take it to the laboratory for analysis, then I'm not going to cause any financial risk to this person or to this organization. Otherwise, this person can come back and say that, yeah, you confiscated our devices or you confiscated our equipment and now we cannot work. And that becomes another liability. So you can only use this when there is no any financial loss that you are causing to that organization. You can also use this method when it is absolutely necessary due to the nature of the particular offense. For example, if you go and you find that this device has got child pornography, now there's no way you are going to leave that device. That device, you'll be able to collect it because that kind of crime is very serious. And you don't need it. You don't leave that device there because something may happen to the evidence. Or you can use this when it is necessary or required to stop activity supported by equipment that is confiscated. If this equipment is actually doing some crime connected to another computer and maybe siphoning data or doing some kind of crime like stealing money from the bank, then it is important that you collect that evidence and take it to laboratory for analysis. The advantage of using this is that it can be performed by anybody without support of expert support. You just go. Somebody does not need, a trained eye does not need to do that. They just go. They are told this is what you have to pick. They pick it and then they go take it to the laboratory. Sometimes you use this because another advantage is that the seizure procedure is usually not time consuming. And the e-evidence is taken under control, which means that you are taking this evidence, you're taking it to the laboratory, and then you'll be able to analyze it later. The other thing is also the e-evidence can be analyzed in a controlled environment because you are taking it to the laboratory, and then you can be able to analyze it later. The disadvantage is that there's risk of damaging the equipment because the person who is handling it, you're not sure whether he knows how to handle the equipment. There is also risk of harming the persons unrelated to the crime in question. This is when it comes to seizure of this equipment or evidence from a crime scene. I'm telling you, this is always not an easy job. Even if we go there with the police, in which case we've done this, and you find that there will always be a fight. These guys will never allow you to collect, even if you have the warrant of collection or the Anton Pillar. It is always a fight. So that is another disadvantage because somebody can get harmed, somebody who is not related to that particular evidence we are talking about. Also, there's risk of interfering with activities unrelated to the crime in question. Now, the other thing is copying the entire memory. And this is what I say, that you go to a crime scene and there are 100 computers. You cannot collect 100 computers and go start analyzing them in the lab. So what you do, you carry your own storage device. And when you carry your own storage device, what you do is now you do imaging. And I've talked about imaging. Imaging means that you are copying the entire disk of that particular computer and making sure that the image that you copy actually is the same, or not similar, but the same as the original. How do you do this? You do this by creating what we call hash value. the device that you are going to do this, the device that you are going to use automatically will create that hash value. And hash value, I said, is a mathematical function that happens when you copy this, the information. And what it does is that it makes sure that the content in the original is the same as the content of the image. So if there's anything that changes on the original, the hash value will actually change. And when the actual hash value changes, and you can be able to prove that in court, then actually that evidence will not be admissible because something has changed. And this is, I don't want to be political, but this is an aspect that was during our election. Some people did not really think about it. It would have done something in the case, but that's just by the way. Now, it requires a special tool to create this exact duplicate of the memory on the electronic device. And so it is used when a considerable amount of equipment to be collected is considered. So as I say, you go somewhere, you find 50 computers, you cannot collect those 50 computers. What you do imaging of each and every computer, create the hash value, and make sure that the original and the duplicate is the same. So there's also a risk of financial or other losses that may be caused by operation of the unavailability or unavailability of the equipment, which means that if you take that device from there, these people are going to be crippled. So you, instead of doing that, what you do, you just copy the entire memory into your storage. And that is what we call copying the entire memory. Now, as you can see, you have that black gadget on the left, and then you have the source of evidence, that is the hard disk on the right hand side. Now, what happens is that this black device is connected to a storage, which can be a computer or any other storage device. So what it does, it is like a glove. When you go to a crime scene as an officer to collect evidence, what do you normally do? You make sure that you put the glove, or you wear the gloves, so that you cannot contaminate the crime scene. So this happens, this device is like a glove. What it does is that it allows the data or the information to be copied from the device for the culprit device, but it prevents any information that moving from the storage, your storage, back to the device, so that the device remains intact, original. And after it has copied all the information, then it calculates that hash value, and then you keep that hash value. Should something change on this original device, and then the hash value will change, and you know, so these people have actually interfered with the evidence. Because sometimes you can go and do this, you copy the entire, then you leave them their device. They think that, oh, we can change something, so that when we go to court, there's no information that is there. That hash value will say that this information has been changed, and that is how you will be able to detect. You can also do seizure by confiscating the backup. In this case, it is just similar to copying the entire, if there's a large amount of data to be copied. That is seizure by confiscating the backup. Seizure by selective data copying. This is what I say, that you go to a place and the computer is on. So you cannot down that computer, you cannot shut it down. So what you do, you just ensure that you connect to that computer. And when you connect this computer, remember, anything that you do must have very, very minimal effect on the data that you are collecting, or the data that is in that computer. So it should only be used under exceptional circumstances, if there's no any other previously mentioned seizure are not possible. So data can be copied by and analyzed later expert support is usually mandatory at the scene, because you have to know exactly what you are copying. You have to know exactly what you are capturing from that particular computer. So that is why it is important that you, an expert person with a trained eye, is the person to do it. The advantages and disadvantages are similar to those for a seizure by confiscating the backup. And further disadvantage is that there can be no historical reconstruction, because whatever you are doing there, you are picking it on a live server, and there's no way you can go to the lab and reconstruct the scene. Copying, seizure by evidence from the internet. We've talked about this. Seizure of evidence from the internet is vital for many investigation types and requires specialist knowledge, skills, and resources to enable it to be carried out effectively, which means that if you are not somebody who has got the special knowledge to collect this evidence, it becomes difficult to collect this evidence. You need to have those special skills so that you can be able to collect open data from the internet. This can be done through covert means, or can be done just through collection of open data. That is what we call open source intelligence, and then converting that data into evidence that can be used in the court of law. Now, I talked about what we call chain of custody. Now, chain of custody is that chronological documentation that from the time you collect the evidence to the time that evidence is brought in the court of law. Now, chain of custody will determine certain things. It will show the court that the time the evidence, it will show the court the time the evidence, the time and the date the evidence was collected or transferred to another agency, or the evidence was collected to and taken to the lab. It also shows that there's no tampering. There's no tampering with the item when it was in the custody of the person who was collecting it. So chain of custody, it should be initiated at the time the evidence is recovered. When you go to the crime scene, when you get that evidence, you should start the chain of custody. And each and every agency always have got this the form that they use for the chain of custody. So the chain of custody begins as soon as the evidence, the seizure takes place, and it concludes when the evidence is scanned, returned, or destroyed. So this is just part of chain of custody that I've shown there. So evidence, before you take the evidence and record it in the chain of custody, you must make sure that you photograph the evidence and ensure that any visible damage which is on that evidence should be photographed, and it should be properly documented in the chain of custody. As I say, chain of custody is something that when you go to court and presenting the evidence, the court will need to see that chain of custody. And that chain of custody will show you from the evidence, time the evidence was collected until that case is done or that evidence is discarded. So that is the first part of chain of custody. The second part of chain of custody is you can see that the description of evidence. What did I collect when I went to the crime scene? As you can see, the item number one, the quantity that I collected, the description of what I collected, and the serial number. I describe each and everything that is in that particular device. And number two, you can see I've listed number two, but when you see row number three, I put dash dash and I put final entry. Now, which means that in a chain of custody, you should be very, very careful if you leave it blank, because somebody might come and insert another device there. So you just make sure that you, once you've collected all the evidence, you cross to ensure that nobody can actually add additional evidence there. The second part, the third part of chain of custody is involving a transfer, which means that if I collect this evidence at this particular time, and this evidence was transferred from my agency to the other agency, I need to put that in the chain of custody. If I took the evidence from the evidence room and to go and analyze it, I have to record it in the chain of custody. So chain of custody will have all the entries regarding that evidence to ensure that that evidence was handled properly, and that the court can be able to ascertain that the integrity of this evidence is maintained. Now, once the evidence has got, the case is done, that is the fourth part of the chain of custody, and you can see that this final disposal authority, I can either authorize this, the court will authorize this evidence to be disposed. The court may authorize this evidence to be destroyed, or the court might say that this evidence should be released to the lawful owner. So all that must be put in the chain of custody. Now, that is actually a diagrammatic representation of chain of custody. And as you can see, from the time the evidence was seized and the evidence was transported, it has to be documented in the chain of custody. Where the evidence was stored in the laboratory, it has to be put in the chain of custody. How it was examined, then taken back to the store where it was sold, until that time that the court will order its destruction or return to the lawful owner. At any point, do not break the chain of custody, because if you break the chain of custody and you take the evidence in court, then that evidence, if it lacks, the court can determine that there's a break in the chain of custody, then that evidence will not be admissible in the court of law. So that brings me to the end of the presentation. Gigi, back to you.
Thank you very much, Lawrence, for a wonderful presentation. I see there's a lot of questions and comments in the Q&A. I don't know if would you like me to read them out for you, Lawrence, or are you going to read them as I go along?
Please just read.
Okay, so the first one, first of all, a lot of the participants are asking if you will have the presentation will be available after the session.
Yes, it will be shared through the East African Law Society.
Thank you. Now, the first question is, someone wants to know whether the legal framework or the statutes where the principles for electronic evidence are found.
Okay. Now, this is a complicated question in terms of it depends on jurisdiction. If we are talking about Kenya, there's the principles that I talked about. There are requirements when you are presenting digital evidence or electronic evidence in the court of law in Kenya. I'm talking particularly in Kenya. Now we have, I think, section 78, which is talking about how to present the electronic evidence from text messages from WhatsApp. Then the most important thing, the most prevalent one is section 106B. Now, section 106B talks about the certificate, how you, when you are presenting that particular evidence in the court of law, how it should be presented and how you should be able to generate that certificate. And this has been shown in cases like in 2014, we had this case of Rasanga versus William Oduol. And if you go through that case, you'll see that the Justice Mchelule dismissed the case which was brought by Oduol because they did not follow the instruction according to section 106B. So I believe that each and every jurisdiction have got their evidence act, which can also take into consideration the electronic evidence.
Thank you, Lawrence. Yeah. The next question, Moza Jadid is asking, do all witnesses have to be trained as experts? What is the status of those first responders or witnesses who encounter a crime and report it on their cell phones?
Now, we have various types of experts. Especially when we are talking about digital evidence or electronic evidence, we have somebody called expert witness. Now, expert witness is somebody who, by education, by training, possess knowledge that can be relied upon by the court of law. So these are when you need to present digital evidence or electronic evidence in the court of law, you must be trained to do this. You must have that knowledge that the court can be able to rely on as somebody who has been trained, somebody who has got knowledge through training or through experience, and can be able to be relied upon. Because remember, as an expert witness, your testimony is very crucial to for the judge to make the decision. You do not influence how the judge makes the decision or the magistrate makes the decision, but they actually rely on your testimony to make the decision. So that is why it is very important that you are an expert, you are trained and have the knowledge that can be able to, the court can be able to rely on.
Okay. The next question is anonymously. It says, can long experience in tech space without training be considered in determining credibility of a witness?
Yes, yes, and that came up in a case. I can't remember the case, but the case there was a case whether it only academic qualification or experience can determine somebody to be an expert witness, and it is yes. Because you remember, if you are a police officer and you've been doing this for the last 10 years, and this is actually your line of duty, then you are actually an expert witness. It does not need to have academic qualification to be an expert witness. Experience is considered as a qualification for being an expert witness.
Okay. Now, I have two people asking a similar question, so I'm just going to group them together, if you don't mind, Lawrence.
Yeah.
So the first one is, who constitutes the chain of custody? And then the next one, it's on how do you ensure compliance with chain of custody principle? Okay.
Now, chain of custody, as I said, is a chronological documentation of what has happened to the evidence since it was collected. So which means that if you ask who constitutes chain of custody, is the person who actually collected this evidence, and a whole chain from when the evidence was collected and the evidence was preserved and the evidence was actually taken to laboratory and stored. Remember, I've shown you the chain of custody form, which has got a lot of information. Why do you collect this information? You are collecting this information just so that we can know the journey of this evidence from the time it was collected to the time the evidence is brought in court of law, so that we can be able to, first of all, have the audit trail. Secondly, know that the integrity of this evidence is intact. Nobody has interfered with it, because that one is documented from the chain of custody. So the chain of custody involved from the investigator to anybody who must have touched that evidence while it is in store, anybody who has analyzed that evidence until that evidence is presented in the court of law. So all that, anybody who is involved in that chain is a custodian of the chain of custody, and that's why it is called chain of custody.
Thank you, Lawrence. The next question is with regards to the example you gave of the case where you were the expert witness. It's a bit long, so just bear with me. So they're asking, what if that evidence was collected on that 2014 case and the case that then it filed in 2018? Are you saying we discredit evidence based on lapse of time as opposed to whether the evidence actually captured what transpired? It may take time before a case is filed. I don't think that means the fact that the evidence was collected before the case was filed makes it inadmissible. Maybe you could expand what exactly you meant when using that particular example.
Okay.
You get that, Lawrence?
Yeah, I get that.
Thank you.
Now, what we said in the chain of custody was that it testified to the time the evidence was collected and the time to show that the integrity of that evidence. Now, in this particular case, it was not that the evidence was collected in 2014. The evidence was actually collected in 2018. What happened here is that when they were collecting the evidence, there was a lot. If I could expand into other things, but there was a lot of loopholes in this evidence. First of all, when I looked at the report, I found a lot that the gadget that was used, the device that was used to collect this evidence, what they did is they forgot to change to reset the date. Okay. The second thing is that why it was also dismissed as such, because this when I looked at the report, the procedure of the type of the device that was used, there was no name of this device. There was no manufacturer of this device. We didn't have a name for the device. There was no serial number. There was no model for this device, and so you could not establish what kind of device it is. That's one thing. The other thing is that when they collected this evidence and through this device and transferred the evidence to the CD, there was no explanation how this was done. But in short, what I meant by this is that this particular case is not that it was collected in 2014. It was a mistake of the investigator in terms of ensuring that the integrity of this evidence can be relied upon in the court of law. So I don't want to go into details about that, but that was the thing. The investigator did not have that knowledge, that skills to ensure that the certain principles regarding digital evidence or electronic evidence is taken into consideration before they presented that evidence in the court of law. But the case was actually within 2018.
Thank you, Lawrence. The next one is asking, are private and institutional investigators also guided by these rules? They also extract electronic evidence, especially for internal disciplinary measures. Do they need a legal authority?
Legal authority is two-way. If you are in the enterprise environment and you are doing the investigation, which means automatically if you are an investigator, enterprise investigator, you have the legal authority to do that investigation and collect that evidence for use internally. Because when you collect that evidence, still you are going to present it to the authority or the person or the employer or the person who actually engaged you to collect that evidence. So in any way, there must be that legal authority, even though when it comes to court of law, in Kenya and any other jurisdiction, you'll find that the private investigators, as much as they will collect the evidence that will be presented in the court of law, they must do that in collaboration with the authority, with the law enforcement. And having the law enforcement collecting that evidence to be presented, they must have that legal authority to do that. But in the enterprise environment, it's a different thing.
Okay, thank you, Lawrence. The next question is anonymous attendee is asking if you record a phone call, a phone conversation without the other person's knowledge, is the recording admissible? And then we have someone else who added on to that. They're saying additional and related questions. How do you adduce such evidence? Can it be stored in a different device, say a compact disk or a flash disk?
Now, if you record somebody without authority, say, first of all, I don't think legally, I'm not a legal guy, but I don't think legally that will be admissible, because I don't even think that you can take that to the court of law. In terms of storage, yes, you can store that information in another device. But remember what I said about chain of custody, is that whatever you do, you have to document it. You have to document it in such a way that, provided you'll be showing that evidence, you will need to show that that evidence is actually the original evidence. If it is a recording, then you have to show that it is the original. There are certain things which we call metadata, which you'll be able to show, and that this metadata, things like the date it was recorded, maybe the device that it was used to record, it was used to record it. Such information must be there. The most important thing here is that when you are presenting that evidence, there should be no doubt that that evidence has been interfered with. The integrity of that evidence should be able to be established by any authority that is going to hear that case.
Okay, thank you. The next question is on CCTV cameras and footages. So it's asking, when CCTV footage is gathered in normal course of business and a party would want to rely on them as evidence in a court of law, how does one ensure compliance with the principle of legal authority? And then we have someone who piggybacked on that question, going on to ask, when the source of the video is unknown, can the eyewitness depicted on the CCTV footage be used as the authentic witness? Will that be admissible?
Remember, I still go back to the principles of digital evidence and how it is going to be presented in court of law. Like if I go I collect evidence from CCTV, there are certain aspects that I'm looking for to ensure that that evidence is actually the actual evidence that was collected on the CCTV. And this is why I've talked about the metadata. So there are certain data that are that particular clip that was collected. And so when I'm bringing it to the court of law, I have to ensure that evidence, that clip that I'm actually presenting is the actual clip and it has not been edited in any way. So I must maintain that the integrity of that evidence is still intact and have to prove that in the court of law. So yes, as much as you collected it from that particular device, there are certain things that you have to do. For example, you have to put the device, the name of the device that was actually recording that particular clip. You have to put the serial number. You have to put the manufacturer. You have to put the model of that evidence. You have to also accompany that evidence with a certificate according to section 106B to show that evidence. There are certain things that you have to follow in that section 106B if you go to the act, the Evidence Act. And provided you follow that and generate a certificate, then that evidence will actually be admissible.
Great, thank you. The next question, this is asking for an example. So it's asking, kind of explain again how the hashing technique works and how do you spot that the hashing technique has been tampered with? If you have an example, that would be great.
Okay, let me put it this way. We know when you are creating an information, here information is used to make a decision. I'm giving you an example. Information is used to make a decision. So if I'm creating information, I know that this information that I'm creating and storing it somewhere in the computer system, I'll use it later on to make a decision. For example, if I'm making doing an order for spares, and those spares is stored somewhere in the store. Okay, so when I come later on one year, I want to make a decision. So, or I want ensure make a decision regarding that. So I need to ensure that the information that I'm using to make that decision is the correct information. So what will I do? I need to verify that the spares that I ordered 2 years ago, are they still there? What will I do? I'll call the storeman to verify that the spares are there so that I can make the correct decision. So hashing, what it does is when the information is known to be good, you create what we call hash value. Hash value is a mathematical function that you run on that particular information, and then it created what we call a message digest or hash value. Then that hash value is a number, okay, is a number. And what happens that if that the original information is changed, even a dot has been inserted in that original document, then hash value will change. So that if the hash value changes, then you know that the information has changed. So if I made when I'm creating information, when information is known to be good, I create a hash value for that information. Then I store that hash value. When I want to make decision using that information, before I make a decision, I'll need to know the information that I created is still valid. Is it still intact? Did somebody change it? Then what I do, I take that information at that particular time. I create another hash value. Then I compare the two hash value. If the two hash values are the same, then I know that information, scientifically, that information has not been changed in any way. Now, when it comes to digital evidence, when you are, remember, you go and pick a computer or you pick a hard disk, and now that hard disk, you don't want to work on the original hard disk because you might interfere with it. So what you do is that you create a duplicate hard disk or an image of that hard disk. Now, when you create a duplicate or image of that hard disk, hash value which you generate through the process ensures that whatever there is the content in the original hard disk is the same as that image that you've created. Now, in case somebody goes and changes the original, then that hash value will change. So, for example, if I come and I know the laptop that you have has got very incriminating evidence. And so, because you don't know, I come and I tell you, oh, I'm not going to pick your laptop. What I'll do, I'm going to create an image, and you don't know what I'm doing. So once I create the image, I've created that hash value. Okay. Then once I go do my investigation and I find the evidence, you know, I come back and say, no, that information is not there because you thought that you had deleted it. So it is not on that hard disk. So what I do, I pick that hard disk at that particular time, and I do another image, and then I compare the I do the hash value and I compare with the hash value that I have. They'll be different. So I know you actually modified or changed the evidence in that particular original hard disk. That's how it works. It's a mathematical function, and you don't know you need to do it yourself. The device that you're using to create that image will automatically create that hash value.
Great, thank you, Lawrence. The next question is on social media vis-a-vis traditional media. The question is, can you reference digital evidence that has been collected from social media sites such as Instagram, YouTube, etc.? If so, how? And then it goes on to say, does the same rules apply to newscasting stations?
Now, social media, whether it's social media, whether it's still evidence. Now, there's no way you can go to social media and copy that evidence and take it to the court of law. What normally happens is you preserve that evidence. When you get that evidence, there are certain tools that you use to preserve that evidence that will create a hash value for that particular site and other part or information that I was talking about. Remember, a lot of information that must accompany this particular evidence. So provided you've preserved that site, and it creates such kind of such information like the hash value, almost message digest, then that evidence you can actually be admissible in the court of law, because you are telling the court that as at this particular time when I was doing the investigation, this was how the site was, and it can be established that yes, nothing changed at that particular time. Because for social media, it is there here today, tomorrow it is not there. So if it is pulled out, then you can still say that I preserved this website, and this is the information that was there at the website on that particular day. There's a case that I was doing, and when the culprits, these guys realized that I was closing on them, then what they did is that they pulled down the website. So what their reason was, now if there's no evidence, there's not that website, how will this guy say that we committed this crime? So what I did is, they didn't know that I'd already preserved the pages of that website, the information that I needed, and calculated the hash values for those pages to ensure that when I present this in the court of law, then it will be admissible as evidence.
Thank you, Lawrence. The next question is with regards to dash cams. And the question is, what is the value of evidence from dash cams installed in vehicles for the purposes of traffic offenses in related matters? Please provide the process that would be applicable for the use of evidence collected by car owners who has installed a dash cam in his or her car that records the traffic offense or accident.
Dash cam is a device. Okay,
yeah.
An electronic device that you use to collect that evidence. Now, that device, when you are picking information from that device, first of all, you have to follow the correct procedure of collecting that information from that device. For instance, you will ensure that that device, in terms of date and times, the date and time of that device is correct. And then you have to ensure that when you are collecting that evidence and transferring it, maybe to a CD, that procedure is well documented. And the other thing is that particular device, when in your report, you have to state that I collected, this is the device that I used to collect this evidence. It is this is the name of the device, this is the model of the device, this is the serial number of the device, this is the manufacturer of the device. And also you have to say that the device actually was working okay in a secure way when I was collecting the evidence. And when you're presenting that evidence, still you need to have accompany that evidence, that device with a certificate according to section 106B. That is when that evidence is going to be admissible.
Thank you, Lawrence. Let me just move on to the live questions. We have a Mark Omona. Mark, please go ahead. Mark. Mark, you can unmute. I've allowed you to talk. Mark, can you hear us? Okay, I guess not. We can move on to the next person who's raised their hand. I have Adila Ali. Go ahead, Adila. Okay, the next person, Okumu Martin. I've allowed you to talk. Go ahead, Martin. Hello, Okumu, can you hear me? Okay, I guess the live people might be experiencing some technical issues. Okay, the next question is with regards to chain of custody in civil matters. Does that apply, Lawrence?
Chain of custody?
Civil matters.
Provided you are doing in investigation involving electronic evidence, then chain of custody must be part and parcel of that.
Okay. The next
whether
question.
criminal or civil.
Okay. Right. Now, the next question is on the exception with regards to chain of custody. The question is there an exception where the chain of custody can be broken?
Okay, let's put it this way. When this you break the chain of custody, what it casts doubt on that particular evidence. Okay, remember what we said about the auditing audit trail. Okay, chain of custody. What it tells the court is that this evidence is credible. It can be able to establish the integrity of that evidence. Now, if there's any break on the chain of custody and there is explanation that you bring to court and the court can establish that the break does not actually significantly affect the integrity of evidence, then it may be admissible. But with an explanation that chain of custody was, because there are sometimes maybe it was you forgot, or maybe it was something that you could not avoid. But the break of chain of custody, why it is not encouraged is because it is going to cast doubt on the integrity of the evidence. So you should maintain it as much as possible, depending on the agency. There are always that form that you use to put all that information, capture that information, to show the court that the chain of custody is intact.
Thank you, Lawrence. The next question is from a forensic investigator from Uganda, who is asking that he would like to, I would like to talk about how one can handle some scenarios where digital evidence has been tampered with. Let's say there is a hack in the target system. How does one go about that?
When there's a hack in a target system?
Yes.
Are we talking about doing the forensic analysis, or because I don't understand, how do you go about that? Because when there's a hack in the system, you have to do the investigation, the forensic analysis to find out what, or how the hack was done. So I don't know whether he's asking in relation to evidence. I don't understand the question fully.
I think he's referring to if there is a digital evidence that needs to be collected, but there has been a hack in the system from the target. How does one maneuver that situation? I think that's what he means.
Okay, I don't know. It's very difficult to answer that question. If there's a hack in the system, now you are dealing with two things here. First of all, you are dealing with the hack itself. Okay, you have to understand, you have to know, investigate and find out how the hack was done, and if the hack was had actually interfered with the original evidence that you wanted to collect. So it depends on many things, many factors. Where was this original evidence found before the hack? And after the hack, did the hack actually interfere with the original evidence? So what happens here is that you are dealing with two cases. You are dealing with the hacking case, and you are dealing with the collection of the evidence. So you need to collect the evidence for the hack, if that is also important for your analysis and for presentation in the court of law. But at the same time, did this hack actually interfere with the evidence that you wanted to collect? So I mean, it depends on which angle you are looking at it. But I think, but according to me, it is this: if the hack was on that particular computer, still you need to investigate the computer. You need to investigate it for the hack, and in fact, and at the same time, you need to investigate for the evidence, the original evidence that you are looking for. So it is not a one-way thing that I can say that this is how to go about it. Depends on the situation that in which you are.
Thank you, Lawrence. I'm going to try again to go to the people with their hands raised to see if anyone will be able to So the next person who has their hand up is again Okumu Martin. Okumu, can you contribute now? I've allowed you again. I've allowed you to speak. Hello. Okay, let's try the next person. We have a Kelvin Muriuki. Kelvin, can you hear us? My apologies for butchering your name.
No problem, no problem. I had a question. Okay, thank you. I had a question. What if the data that you want is sent from another phone or from another device, and that certificate of authenticity is needed in court? Do you have to authenticate the other device that sent you that data, or are you going to authenticate only your phone and your printout?
First of all, where was the original data?
Maybe from a client.
From a client.
From his phone.
From his phone. So,
but he did. Continue. Yes. Continue. Sorry. Continue.
Yeah. If it was, that was which phone created the evidence?
The phone that created the evidence or that collected the evidence is my client's phone.
Yes.
But since he can't the data in his phone, he doesn't have the capacity or the equipment to output the data in his phone.
You see,
maybe like a printer or something. So he has to send it to me so that I can maybe access that data from my printer, so that it can be maybe tangible evidence. So I have to certify my printer and my phone. But do I have to certify his phone?
Yeah. In this case, you see, okay, when the data is sent from his phone to your phone, and it comes to your phone, there's aspect of that data that has changed in terms of dates and time. It's not the original phone. So legally, your phone is not the original device that created the data. So what you can do in that case, you have to actually explain it to the certificate. What I don't know whether the court will be able to allow that. You can you have to do what? The original form that you have to include in your certificate, the original form that created the certificate. Okay. And that person must satisfy that, yes, yeah, that the evidence was working perfectly at the time. Then you can also include that it was sent to you. And when it was sent to you, you also include things like the serial number and the date that, because now the dates has changed when it came to your
yeah, that's true.
Yeah, I think you get me. Yeah.
I got you. Thank you so much.
Yes. Gigi? Gigi, are you there?
Hello, can you hear me?
Hello.
Yes, Gigi.
Oh.
The next person to ask a question is Edie Cassie. Edie, can you go ahead?
Yes. Sorry, can you?
We can hear you. Go ahead.
Okay, thank you. I asked a question previously about the CCTV footage, especially when the source is unknown. I understood the presentation on the principles of handling electronic evidence, but now let's say the source of the video, the footage, is unknown. Now, can we use the eyewitness who can?
Sorry, Edie, we lost you there for a second.
Footage as a okay. Hello.
Can you repeat the question? We lost you there for a second.
Yes. I remember I added a question on the CCTV footage, especially when the video is unknown. The source of the video is unknown. Now the question is, can we use the eyewitness who can be depicted from the CCTV footage as an authentication witness? Can we use that, and can it be admissible?
Remember integrity, and I said I'm going to talk about integrity. Now, integrity means a lot of things. Integrity, as much as we can establish that the data is accurate, integrity also means authenticity. Authenticity means that the source of that data. Can you be able to establish the source of that data and to be authentic? Now, unknown footage, because the source is not known, it cannot be authentic. Therefore, it cannot meet the threshold of integrity. So there's no way the court, in its legal mind, will be able to take it as evidence if you cannot be able to authenticate the source.
Thank you, Lawrence.
Thank you, Lawrence.
Right, the next person, we have a Priscilla Nduta. Can you go ahead, Priscilla, please? Hello, Priscilla? Can you hear us? Priscilla? Okay, let's try the next person. We have a Busegi Kulwa. Hello, Busegi. Busegi, can you hear us? Hello. Hello. Okay, Lawrence?
Yes.
Just allow me to go back to the questions in the Q&A, because I think we're having some issues with some of the participants with the live questions. Okay, so the next question here, some of the questions are repeating themselves. So the next question is with regards to, okay, there's a question here about the laws. We've covered that would depend on the jurisdiction. So I will not go on into that one. Okay, so the next question is with regards to recording a conversation without the other person's knowledge. Now the question reads that when I record a conversation without informing the other person, is that evidence admissible? Picture this: if you're illegally terminated from employment and you recorded a meeting which has a lot of incriminating evidence from the employer, can that be used?
Now that question I can look at it in two contexts.
Yes.
First of all, there's issue of privacy. So the issue of privacy will kick in. Secondly, when it comes to evidence and it has to be admitted, then it has to follow the principles of collecting evidence, best practice in collecting evidence, which does not touch on the privacy now, but it touches on the principles of collecting that evidence and presenting that evidence in court. I've talked about presentation. So presentation part of it, you just must ensure that you comply with the evidence law and you generate the certificate, you put all the information that is needed in that certificate. Then at that particular time, without aspect of privacy, then should it be supposed to go on court, to court, then it should be technically admissible, but legally is something else because it borders privacy and also it borders the legal aspects. But technically, yes, if you follow the correct procedure for collecting, preserving, and presenting that evidence, it is admissible technically.
Thank you, Lawrence. We have a question here with regards to the tools of the trade. Which tools do you use for forensic analysis?
There are several tools for forensic analysis. There are open source tools and there are commercial tools. Now it depends on your favorite tool that you want to use. But for law enforcement, you find that let me put it this way. When you're doing forensic analysis, the way you do forensic analysis on a computer or on a laptop is different from forensic analysis of phone. So we have different tools for different purposes. For like for computer forensics, we have tools like NCASE. We have tools like FTK. For phone forensics, we have things like the Oxygen. We have tools like Celebrite. We have tools like X-Ways. There are several tools in.
Lawrence? Hello, we've lost you there for a second.
Open source, while we have things like autopsy tools, both commercial and open source.
Hello?
Yes.
Thank you, Lawrence. So I'm aware of the time. We only have 2 minutes left. Is there anything else you would like to say as a closing, Lawrence? Before I hand over back to ELS?
Not much now. I just want to say thank you for the opportunity that you've given me to interact with your members base. And I think this is something which is very important, because nowadays you find that when you go to court, most of the evidence will border on electronic evidence. And evidence that nowadays is mostly brought in court is electronic. So it is very important for lawyers to understand the concept of digital evidence, so that when they go to court, they will be able to understand actually when the expert witness is talking, they can be able to grab this issue. Because I tell you, I've gone to court several times, but when I stand there to be asked any question or to be cross-examined or direct examination, I find that mostly lawyers do not have anything to ask me. So that is why it is important for us to build capacity for lawyers to ensure that they can be able to understand this new concept of digital evidence, so that they can be able to represent their clients well in the court of law. Otherwise, thank you very much, Gigi, for the opportunity.
Thank you very much, Lawrence. We really appreciate you taking the time and educating us in such a complex subject. And we hope that we'll get more from you from the next session. David, are you there?
Thank you very much, Gigi. Yes, I'm around.
Hello?
On behalf of, Gigi, you can hear me? On behalf of the East African Law Society Council, I would like to thank you all for attending this very informative webinar session. I believe now you'll have questions to ask experts like Lawrence Dinga whenever you are called to cross-examine them in court. We've had really good turnout, and I can see most of you are still on. We have a lot more arranged for you. We are planning from next month to have at least 2 sessions a week in different topics, ranging from young lawyers to all other expert areas of training. We're going to share that training calendar with you, so be on the lookout. And we are going to look forward to hosting you again. Thank you, Gigi. I think that was a marvelous moderation.
Thank you.
I believe myself, I enjoyed, and probably everyone else in this call really enjoyed listening to you moderate this session. Thank you, Lawrence. It's always a pleasure to have you. You have proven yourself beyond any doubt that you are an expert in this area, and we really appreciate you taking time to facilitate this session. And we are hoping that in the next 2 sessions that we're going to have with you in the area of electronic evidence and cybercrime, we are going to enjoy as much. To everyone, have a nice evening, and we look forward to seeing you.
Thank you, David.
Thank you, David. Thank you, Gigi.
Thank you, Lawrence. Thank you, everyone.
See you next time.
Bye.
Bye-bye.